I bet you're scared to go to prison. I bet you don't want to go to prison, but I see these tears as actual remorse. We will go on the record in the matter 23 CF 158, State of Wisconsin versus Robert Canfield. The state appears through District Attorney Kevin Schmidt in person. In person, we have Mr. Canfield appearing in person in custody without counsel or with counsel Nicholas White. We're set today for a plea and sentencing. This appears to be an OWI 7th. Is that correct, Mr. Schmidt?
Yes.
All right, Mr. White, what is the agreement that's been reached?
Thanks, Judge. There's an offer here for plea to the OWI 7th, count 1, and also the attempting flee or elude an officer, count 2, merge and dismiss, count 5, dismiss and read in counts 3 and 4. There is an option of requesting a PSI or not. We plan to waive the PSI and have a joint recommendation for the statutory minimums on the OWI 7th with a minimum of 3 years initial confinement on the prison sentence there, a concurrent sentence on the flee or elude charge, court cost, and supervision to include AODA and follow through.
All right, thank you. Do you have a plea questionnaire?
Yes, I do.
Thank you. Mr. Canfield, that's the agreement that you've reached with the state?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you?
Yes, he did.
Did he go over it thoroughly with you?
Yes, he did.
Essentially, did he read it to you word for word?
Yes.
And so you understand everything on this document.
Yes, I do.
If you didn't understand something, did you have him explain it to you until you did?
Yes, I did.
Is that your
Your Honor.
signature on the second page?
Yes, it is.
You are pleading guilty to 1 count of OWI operating while intoxicated, 7th offense, and attempting to flee or elude an officer. Is that correct?
Yes, it is, Your Honor.
You're 36 years old. You have 12 years of schooling. You can read, write. You understand the English language. That's all correct.
Yes.
You have not had any alcohol, medications, or drugs within the last 24 hours, and no mental illnesses or defects, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt to both these charges?
Yeah, we went over quite a bit of stuff, so I think so.
Did your attorney go over with you the maximum possible penalty you face for both of these charges?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on the front page of this document. Did your attorney thoroughly go over your rights with you?
Yes, he has.
And do you understand them completely?
Yes, I do.
You understand that you will no longer have the right to a trial. You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, I do.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation.
Yes, I do.
You also understand you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, I do.
You will no longer be able to vote in any election until your civil rights are restored.
Okay.
And you understand that?
Yes, I do.
All right. Do you also understand that with regards to this matter, the state would have to prove on or around August 28th, 2023 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a class F felony, and this would be counted as your 7th offense. Do you understand what the state would need to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 12 and a half years or both?
Yes, I do.
Do you also understand that with this sentence, there is a mandatory minimum and the court shall impose a bifurcated sentence of the confinement portion to not be less than 3 years of initial confinement. Do you understand that?
Yes, I do.
Do you understand that with regards to count 2, attempting to flee or elude an officer, the state would have to prove the same date, the same time, the same place, that while operating a motor vehicle on a highway after having received either a visual or audible signal from a traffic officer, a federal law enforcement officer, or a marked or unmarked police vehicle that you knew or reasonably should have known was being operated by a law enforcement officer, you knowingly fled or attempted to elude a traffic officer by increasing the speed of your vehicle in an attempt to flee. Do you understand what the state would have to prove?
Yes, I do.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both.
Yes, I do.
You also understand that upon conviction, the Department of Transportation shall revoke your operating privileges for 6 months.
Yes, I do.
Now, do you also understand that there is an agreement here between the parties for a recommendation to the court of the mandatory minimums as it relates to that OWI 7th and to have a concurrent sentence for that flee and elude? Do you understand that I'm not bound to follow that recommendation?
Yes, I do.
That means I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
Yes, I do.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Now, did you review that criminal complaint with your attorney? And in particular, there is a section there called the probable cause section where it basically says what happened that day and why you were charged with these crimes.
Yes, I do.
For the most part, are those facts accurate?
Yes, they seem like it.
And so you're admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant, 7th offense.
Yes, I do.
And you're admitting here today that you in fact did flee and elude an officer.
Yes, I do.
Are you pleading guilty to these charges because you are guilty of these charges?
Yes.
Mr. White, may the court use the probable cause section of the criminal complaint with the statements made by your client to find a factual basis?
Yes, ma'am, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Far as I know, yes.
And has he discussed with you a potential of possible defenses or a lack of defenses you could have in this case?
Yes.
Did he talk to you about the discovery, that evidence, information that he received?
Yes.
Did he also talk to you about what could happen if you were to go to jury trial?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
Not that I can think of.
As to count 1, OWI 7th, a class F felony, how do you wish to plead?
Guilty.
As to count 2, vehicle operator flee or elude an officer, a class I felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of count 1 and count 2. Counts 3 and 4 will be dismissed and read in for purposes of sentencing. Count 5 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Judge, I think this is a case where the court should be doing the minimum of confinement, 3 years initial confinement, and then suggest 3 years extended supervision, run the other case concurrent. You probably noticed on this one in the criminal complaint, there's something peculiar with Mr. Canfield's history. First of all, his history is only the OWIs and driving inimical to public safety, which is Minnesota's version of driving without a valid license or driving while revoked. Every single one of his OWIs occurred between 2016 and 2018. So they were all within a 2-year period of time. He was sentenced on them all around the same time. At the same time, he was committed 3 different times civilly for mental illness. He's been found not competent for unspecified schizophrenia or psychotic disorder multiple times. I think in this case, the timing of those commitments, 2016, 2018, 2020, and when those past OWIs occurred and the gap that's occurred since then, 2018 now to 2024, 2025, I think that demonstrate that there's a connection between his drinking and driving and maintaining mental illness and treating that. I think when he is treating it, he probably is much less likely to commit this offense, which I know is kind of unusual with this type of offense. So for that reason, I think the lower confinement period is appropriate. I think the real goal is to get him on supervision, to monitor, to make sure he's taking whatever medications he needs, he's acting cogently, he's acting sober. And for that reason, I think this is the sentence that best will appropriately address him. Additionally, one thing I talk about a lot when we talk about sentencing in OWI is the whole idea of the Wisconsin plan for the OWI sentencing scheme is we keep ratcheting up each conviction, higher and higher penalty. When you have a person who just racked them all up in a short period of time, all had them at the same time, it's a little different. Like even on his last one, he only got 193 days jail in that. So he hasn't had the ratcheting up you'd have in Wisconsin, because Minnesota's scheme works a little differently. So for those reasons, I'd ask the court to follow the agreement. Thank you.
All right, thank you. Mr. White.
Thank you, Judge. Looking at the charges here, it's no doubt this all very serious, especially with the underlying facts. There's a high PAC that was received by the lab. That's merged in count 5, but it's a fact nonetheless. I'm not going to spend much time talking about the facts here. It's not good. What I can talk about is my client's taking accountability. And today he's going to be sentenced after this case has been pending for about 2 years. There is some interesting information there looking at his history, like the prosecutor brought up with the OWIs and competency all happening right around the same time in 2016 to 2018. I spent a good amount of time looking at the prior offenses here from Mr. Canfield because just starting with the dates that were given in the complaint, there's a missing incident date. There's 2 convictions on the same November 20th date. At first glance, it appears there's duplicate convictions, but I did look at the Minnesota history, each case by case. Unfortunately, this is a 7th offense. He did have 5 prior offenses in Minnesota. My understanding is that he still has some supervision to go on at least 2 of those cases. This is not over with today. However, the sentence goes. A strange kind of timing in this case is looking at a sentence credit and seeing. I think there was a failure to appear in May of last year, and an active warrant in Burnett County for failure to appear. During that time, my client was completing treatment in Kinnick Falls, an alcohol and drug abuse services, which is a halfway house in River Falls. He graduated that in August 2024. So it appears that even though he was on warrant for his arrest, he still was seeking help for these problems and what led him to the OWI. I know this information just because I have a certificate of completion. It was signed by the counselor there, August 1st, 2024. So just going to my client's character and rehabilitative needs, he has been attempting to address this throughout the last several years, and even since this incident happened, since he posted the bond. He graduated in March of 2024, which was just 2 months after he was released here, I think, that he completed New Beginnings Inpatient Program. That certificate was signed by Jeffrey Dalik. And then there's also just a letter from that same time frame from Mr. Rick Mann, March of 2024, a therapist just writing a letter on behalf of Mr. Canfield stating that he's attended many. Actually, he does not miss group or individual sessions. He's been in class and groups for days, sometimes the entire day, beginning to end, and he's benefited from that treatment program. I think it's the type of treatment program that helps him out the most. Your Honor, I'm asking to go along with the minimum sentence here. I think that 3 years, it might not be the sentence that's going to work in every case, but this is going to be the longest amount of time my client's had in custody. And for those reasons and what he's done since the incident, I'd ask you to go along with a 3-year recommendation for confinement. I would also agree with a 3-year recommendation for extended supervision, concurrent on both charges there. Thank you.
Thank you. All right, Mr. Canfield, I'm now going to give you an opportunity to make a statement if you wish to do so. You don't have to, but it is your only opportunity to tell me anything you want about this case, anything about you, about your journey. But you don't have to. Again, I see that there is something written in front of you. I'm not sure if you're going to read something to the court, but if you do, please read it slowly so that my court reporter can take it all down, okay?
Okay. So yes, I do just want to say something short. I just wanted to let you know that I am truly sorry that I put people in the community at risk of being hurt and the officers. And as he mentioned, the treatment stuff, from February 21st to March 29th, I was at New Beginnings and graduated on March 29th, which is a high intensity inpatient. And then on March 29th too, I went to Kinnick Falls in River Falls, Wisconsin. And I went to treatment there for a little over 4 months and graduated on August 1st. And then from there, I was living at a sober house, part of the Servant of the Shepherd Church in River Falls, Wisconsin, up until I got picked up on this warrant. And I just wanted to let you know that my life was actually better than it's been in years while I was out there. That's all I got. Thanks.
Thank you, Mr. Canfield. Mr. Canfield, I do commend you for the things that you did and the programs that you completed and that you focused on your sobriety and having a better life when you were absconding. Still doesn't excuse the absconding. That's why when you were, I believe you were picked up on the warrant, and that's why the cash is so high, because the court couldn't assure your appearance on the original, I can't recall off the top of my head, but $4,000 or something of that nature of what the original cash bond was set at. $5,000. That's a significant amount of money to lose. That's a lot of money to lose, Mr. Canfield. But that wasn't enough to assure your appearance. I wasn't aware of the mental illnesses or disorders that are affecting you. Here, you're not receiving treatment for them. That's what you put on the plea questionnaire, but you do have a history of mental health issues, and the state recognizes that. And so it's glad to hear that in the arguments and to take a different perspective. Because when somebody looks at an OWI 7 conviction, that's extremely serious, extremely serious. I don't know how Minnesota does it over in Minnesota. I do know that their first one is a crime, although Wisconsin's is not, but it doesn't sound like Minnesota is as strict or harsh or punishes as much as Wisconsin does for higher OWIs. If you're OWI 6, you only sat 163 days of incarceration. And now with an OWI 7 in Wisconsin, you're facing at minimum 3 years of incarceration. And that's not even getting to participate. You get no ability to participate in that initial confinement in early release programming. It's a mandatory minimum. This is serious. An OWI 7th is extremely serious, even if in Minnesota, each and every time you could have put not only your life at risk, but so many other lives at risk. I just had a homicide by intoxication, by intoxicated driver sentence yesterday. Somebody could have died. You cannot ever take that back. I'm really hoping that you are focusing on your mental health and making sure that that's under control. It sounds like something went awry during that period of time, 2016 to 18, and then 24 and 2024. Perhaps you were not taking your medications as you should. Perhaps something else had you spiral, and then you weren't going to seek your mental health. Unfortunately, it has caused you to be in that seat, sitting in orange, now going to prison. As much as people may think, I don't like sending people to prison. It's not my favorite thing. I'm taking away your liberty. I'm taking away your rights. It's not something that judges look forward to doing, especially when you have a mandatory minimum case and there's no discretion involved. Your criminal history appears only to be operating while intoxicated, and again in that short little stretch of time, and then now in 2024 with this incident. You don't have a huge criminal history. You do have rehabilitative needs that you can seek services while incarcerated, but you need to continue to seek those services when you're not incarcerated, because that is key here. And that is a focus of this court, and that will be a focus of this sentencing part. The community is at risk when you are out of being incarcerated, when you're not incarcerated, if you are not engaging in those services, if you are not going to your AA, if you are not going to your mental health therapy, if you are not taking your medications as prescribed, the community is at risk. OWI could mean somebody's has either been significantly injured or dead, or you. And Mr. Canfield, you sound like a nice guy, and I'm seeing those tears. I usually have good tuition, and I can tell when they're fake. I think yours are real. And I don't think you're crying to the court because you are scared to go to prison. I bet you're scared to go to prison. I bet you don't want to go to prison, but I see these tears as actual remorse of actually understanding what you did, understanding what could have happened, and feeling terrible about it. With this case, I'm going to tell you, before I had heard the background information from the attorneys about you, I was definitely considering separate sentences consecutive to each other, and thinking that if I do that, then you have to sit your 3 years for your OWI, and with the other sentence, you would be able to engage in the substance abuse programs. You can still do that in prison, but you wouldn't get early release with your OWI. That was my way to try and ensure that you do engage in the substance abuse programs. But then again, hearing what you did while you were absconding, while you weren't here with your cases, it leads me to believe that if left alone and you are released and you have probation overseeing you, that you will continue to engage in that treatment. Because I don't think you like the person that you are sitting in orange, or at least the person that you were on August 28th, 2023. That is when the incident actually occurred, was in 2023. So with regards to this matter, the court is going to sentence you to 3 years of initial confinement, 3 years of extended supervision, and I am not making you eligible for challenge incarceration program or for the substance abuse programming, any early release while you're in your initial confinement stage. You could be eligible for that on the extended supervision if you are revoked. So that's something to pay attention to. I think that recommendation is a good recommendation. You'll have 3 years once you're released to do what you need to do and hopefully stay on that path and not self-medicate with the alcohol. The court is going to assess $6,002 in fines and fees and and surcharges, plus a $10 blood draw fee. You're going to need to make payments for that to be collected by the Department of Corrections while you are in prison at a percentage determined by the Department of Corrections to be reasonable. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, AODA assessment, and follow through. Take your medications as prescribed. Continue with your mental health treatment as recommended. No bars, taverns, liquor stores, casinos, or any establishments that have the primary purpose for the sale or the service of alcohol. Regular alcohol testing. As it relates to the fleeing and eluding, the court is going to sentence you to 1.5 years of initial confinement and 2 years of extended supervision to be concurrent with the OWI sentence. The court is going to order that you provide your DNA. I do not believe that this is one that it can be expunged from the system, but you can check. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you because you're always going to owe it, but the court will issue a warrant and you could sit up to 6 months in jail. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. With the fleeing and eluding, again, I was contemplating a consecutive sentence because of the fleeing and eluding and the increasing speed, but this wasn't a high-speed chase. This wasn't where you were going 90 or 100 miles an hour. So could the public have been at risk? Yes, but it wasn't a substantial likelihood when you were not driving erratically and at a very high speed. You have 305 days of jail credit. That does not include today, correct?
That's right, Your Honor.
So 305 days of jail credit. I think that covers everything, Mr. Schmidt.
Nothing from me.
Mr. White.
Just making sure it was stated on record, we did agree to waive the PSI. I talked about that with Robert. We wanted to go right to sentencing today. The other issue that he brought up with me is, I don't know if it applies to a prison sentence or if it's just a county jail sentence that he has been an inmate worker in the county jail. I think he's been doing that for a couple months. Okay.
There's no good time for prison sentencing. That's why we're truth in sentencing.
Okay. Just wanted to bring it up. All right. I think that was it.
So you can understand that we're different than Minnesota. In Minnesota, you kind of get some good time or some things off of your sentences. In Wisconsin, you do not in prison. You do in jail, you do not in prison because we have what's called the Truth in Sentencing Act. And our sentences are truly the sentences unless you are able to engage in early release programming. In this particular sentence of initial confinement, you are not eligible because of the mandatory minimum. Okay?
Okay.
All right. So, and as it relates to the fleeing and eluding, the court is going to assess only $250 for the DNA surcharge. If that is all, then we are adjourned. Good luck, Mr. Canfield.
Thank you.
I hope you engage in programming while you're in custody in prison, even though it's not going to benefit you with early release.
I will.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.